Okay, earlier today, the Supreme Court heard arguments in the consolidated cases of two conservative nonprofits that are challenging California's donor disclosure requirement. Now, under this requirement, nonprofits soliciting donations in California must be required. They're required every year to submit reports that include lists of names and addresses of their top donors. Wonder what they're going to do with that. Well, we know what they're doing with it because they've targeted many of these donors. Americans for Prosperity and the Thomas More Law Center are the two cases before the court. They say the requirements unnecessarily open up donors to harassment and intimidation for engaging in activity protected by the First Amendment. And I know that's true because that's exactly what's happened. With me now to talk about this case is John Bursch. He is a senior counsel and vice president of Appellate Advocacy with the Alliance Defending Freedom. He is representing Thomas More Law Center in this case before the Supreme Court. John, welcome back to the program.
Thank you. I'm happy to be here.
John, in reading through, I listened to some of the oral arguments today and then reading through the transcripts. I mean, it sounds like both on the ideological right and left, there are concerns about what's happening there in California.
Yeah, it was really remarkable that all 9 justices asked questions and made comments that were pretty favorable to the plaintiffs and hostile to the state of California. And that's consistent with the friend of the court briefs that got filed in this case. There were over 250 groups in more than 40 briefs that filed in support of the Law Center and the foundation. And they ranged all across the ideological spectrum, from conservative groups to the ACLU to the People for the Ethical Treatment of Animals. And more so than any Supreme Court case that I've ever seen, folks on the progressive, libertarian, liberal, conservative wing, didn't matter. They may not have ever agreed on anything before, and yet they all agree that California's compelled donor policy is unconstitutional.
Now, give our listeners a sense of where this policy came from.
Well, this was originally the policy of then Attorney General Kamala Harris, who is now our vice president. And she said that an upfront disclosure requirement that would allow her to collect tens of thousands of these lists from charities affecting thousands and thousands of donors, hundreds of thousands to millions over time, was necessary to prevent charitable fraud. But the record at trial, there were 2 trials in this case, established 2 things. One, California never used that information prior to filing a complaint. And 2, once they filed a complaint and initiated an investigation, they were very easily able to get this information from the impacted charity. And so it was basically a solution in search of a problem. In the meantime, you had all these Schedule Bs with all the donor information on them in the California Attorney General Office's data banks, where they were mistakenly put up online, where they were routinely hacked. Essentially the office leaked that information like a sieve. And what that does is it chills donors. It either causes them not to give or to try to give at contribution amounts that might stay below the Schedule B threshold, or it forces charities not to solicit in California at all, and to put a restriction on their ability to speak to California residents, unless they turn over this information. They just can't do that under the First Amendment.
So just to be clear on this was a unilateral decision by the California Attorney General, then Attorney General Kamala Harris. She did this on her own. This wasn't an act of the legislature.
Correct. She did this unilaterally. It was a bureaucratic policy. It was then followed up with Attorney General Becerra, who is now the Secretary of Health and Human Services in the Biden administration. He continued the policy and litigated it vigorously up the chain. There's now a new AG in California. As of last night, they have not backed off the position in the 24 hours that they've been in office. But the entire time, there was never a legislative judgment. There wasn't even an act of the governor. It was simply bureaucratic nonsense by folks who had all kinds of other things that they could be doing rather than harass charities for their private donor information.
So, John, you mentioned the security issues. Justice Samuel Alito pointed out that the district court actually found that California security lapses were, quote unquote, shocking. And then Justice Sotomayor actually added that reasonable donors might no longer have faith in California.
Yeah, I thought that was remarkable that she added that, because she might not be as sympathetic as some other justices to the First Amendment interests at stake here, but she even understood the chill. And that again goes back to the diversity of political ideologies that were represented in the amici, and also is well established with the trial evidence. Thomas More Law Center, for instance, had testimony from clients and from employees who had been doxxed in all kinds of ways. They had been threatened, they had gotten harassed. They had, in one instance, even had an assassination attempt against them because of their religious ideology. Americans for Prosperity Foundation pointed to much of the same evidence, and the amici briefs were just replete with that kind of information about all kinds of organizations who had been publicly harassed simply because of the positions that they staked out. And when you do that, and then you're looking to donors saying, hey, I want you to give a lot of money, but it's possible that you could end up on the California internet site where everybody can see you, that's just a huge problem. One thing that wasn't discussed in that argument is that it's not simply an issue of those who are fearful of harassment and intimidation. There are those who, for religious reasons, may not want their donations exposed publicly. They want to keep those confidential. And you may just be a person who doesn't want to be solicited by every charity under the sun when they find out that you're a high-rolling donor that gave a lot of money to somebody.
So what was the primary thrust of the plaintiffs in this case in terms of defending their association? Was it an issue of an association, free speech, or a combination of both?
It was a combination of both, and it was rooted in an old case from 1958 involving the NAACP, which also filed an amicus brief in support of the plaintiffs. In the NAACP, it was the Jim Crow era, and Alabama and other southern states were demanding that they hand over their membership list as a condition of doing business in those states. And that had predictable results in the Jim Crow South. The NAACP lost 50% and more of its members in those states. And the US Supreme Court recognized that the First Amendment protects the freedom of association, and that in those cases, the demand for membership lists was chilling the First Amendment rights, not only of the NAACP chapters, but also of their supporters, and that was unconstitutional. So you fast forward to today, and that's really a direct analog of what's happening here.
Now, John, you mentioned that the AG's office, then AG Harris, now Vice President Harris, claimed that this was necessary to thwart fraud. Has any other state determined that this is the only way that they can fight fraud in charitable contributions?
There's very few. There was a multi-state amici brief that was filed by 27 states, I believe, that explained that California is one of only 4 states that does this. And even in the other states, they've got some parameters that make the disclosure requirement a little bit more limited, at least. California's is as broad as it possibly can be. It extends to any charity in the country, even if their top donors don't reside in California. So the notion that somehow this was necessary for them to ferret out fraud is just completely inconsistent with the experience, not only of all these other states, but of California itself. Those trial court findings that said they didn't need the Schedule Bs up front because they could easily get them when they started an investigation, those weren't just random musings of the trial court judge. It was based on the actual testimony of the witnesses that the Attorney General's office provided to testify in this case. So really is crazy.
Is it far-fetched, John, to say that, when you've got, 2 AGs that we've had, Kamala Harris and Javier Becerra, that, very, very liberal. Not even just slightly liberal, very liberal, leftist, that they would be in control of this type of information, and that there might be those working within their agencies that, I want to make sure people understand what you were saying here. This is not just donors in California. They would have access to donor information, top donors of organizations, even if those people did not live in California. There could be somebody within their agency that would like to release that information, like we've seen happen before with the IRS.
Yeah, and that's the problem, and we've seen the consequences of those who have their public information exposed. Cost the Mozilla CEO his job because he donated to an organization in California that supported
the Prop 8. I remember that right. Well. And just although recently, he's got a new system out, Brave, and I highly recommend it for people. He bounced back, and he's got a great the service there called Brave, so it works well. But that's exactly what happened in that case.
Yeah, and let me give you an example that happened just in the last week. There was a paramedic who donated $10 through, essentially GoFundMe. It wasn't that particular platform, but it was similar, a charitable funding vehicle for Kyle Rittenhouse's defense fund. And the donation was anonymous, but that server got hacked. The information was made public. The employer of that paramedic is now investigating them to see if they violated any of their policies because they made a $10 donation. And a reporter showed up on the paramedic's front doorstep to ask how he could be such a terrible person that he would give money to Kyle Rittenhouse's defense fund. That's what you're looking at when you give government officials broad access to confidential donor information.
And I know that several of the justices made that point. In particular, Justice Thomas pointed out that, today all these different groups are labeled, whether they're a racist, white supremacist, a homophobic, that these labels are put out there, and this information being, released, causes people to be targeted. This could very well be used as a tool to choke off funding to conservative organizations that the left disagrees with.
Yeah, there's no question that that's a risk. And I thought Justice Gorsuch made an excellent point along those same lines, that if California would prevail in this case, then just donors is the tip of the iceberg. The government would be able to ask for all of the people that are on your Christmas card list, or they could ask for all the people that you've dated. If they could come up with some trumped up reason why the government had an interest in acquiring that information. An analogy that I use with the non-lawyers to help them understand this is that law enforcement officials would love to have an excuse without a warrant to randomly go into houses whenever they wanted to and just see if any criminal conduct is taking place there. That would certainly help them ferret out if crimes are being committed and maybe even stopping some before they started because of deterrence. But we would never allow that because that's such a huge intrusion on constitutional rights for such a minimal government benefit. It's a radically disproportionate ratio. And so we don't. We require the government to go to court with probable cause to get a warrant from a judge signed and then served so that they can have the right to violate somebody's rights. And here California can do that exact same thing. They can do it all after the fact.
Well, actually, to elaborate on your analogy there, it would actually require people to check in with the police every day and give them their daily planner. That's what would be required in this. I mean, it is very, very invasive. Very quickly, before we run out of time, John, how big of a decision will this be one way or the other?
Well, it could be very big. It could be a little more narrow. They could say it's unconstitutional only as applied to these two plaintiffs because they were able to show the chill. I got the feeling that the court wanted to go broader than that. But really, the big victory here, I think, would be to see the court expound on and develop more of its free association jurisprudence. They're pretty good on free speech generally, but free association is a right that has kind of been left to the dustbin. We haven't heard much about it since the NAACP case and a few later cases in the 50s and 60s.
In many ways, that is even a more important aspect of this, given this cancel culture and what's happening in the world today, is that people have the freedom to associate with others of like mind without being targeted, losing their jobs and incomes. John, thanks so much for joining us. We'll be watching this very, very carefully as the decision comes out, probably in June of next year.
Of this year, actually. We expect a decision by June 30th when the court recesses for the summer. So definitely keep your eyes open for that. And I'd be happy to come back and talk through the opinion.
Absolutely. Look forward to talking to you then. John, thanks so much for joining us.
Thank you. Take care.